Welcome back. The Supreme Court of Appeal in Bloemfontein yesterday awarded damages to the family of 5-year-old Michael Komape, who fell into a pit toilet and drowned at the primary school in Limpopo. This was back in 2014. The family was seeking 3 million rand damages caused by the grief of their child. In 2018, a High Court judge dismissed the family's case against the Department of Education. Section 27 said it was appealing the dismissed damages and claims, as well as the court's refusal to grant the order. We did invite the Department of Education to react to the judgment. However, they said that they were still studying it. But Dr. Faranaaz Veriava, the head of education rights at Section 27, joins us from our Sea Point studio to tell us a little bit more. Good to have you on the program. Thanks so much for being with us, Doctor.
Thank you very much for having me, Leanne.
Many talking to this being some sort of vindication for the family. Are you satisfied with the settlement that's been handed down to the family?
Yes, we are incredibly happy with the judgment, and we are very happy with the damages. We think this has been a long, hard road for the Komape family, and we hope that this brings them a certain amount of closure for what has been a very difficult time, and where their dignity and the dignity of Michael has been repeatedly blasted by the manner of Michael's death and by the way they were treated by the Department of Education and by the state attorney during cross-examination. So we feel very vindicated.
Yeah, I mean, let's go back a little bit over this, because, you know, when one looks at how this case unfolded, it really was a hard one to watch. So if I've got this correct, the Limpopo High Court in 2018 dismissed the claim for constitutional damages. At the time, it was Judge Gerrit Muller who only awarded 6,000 rand to the family for future medical expenses. And then it was in November that the Department of Education made a partial settlement of 100,000 rand towards funeral costs, loss of income, and psychological medical expenses. It's like you say, this has been a really, really tough time. Section 27, you never ever felt that this was adequate recourse?
No, we never felt that it was adequate recourse. And I think what Judge Gerrit Muller's reasoning was that he wanted some kind of systemic damage, which targeted fixing pit toilets in the province. He has given a structural order saying that government must come up with the audit of the number of toilets, pit toilets in the school, and then come up with a plan to fix those toilets. But we felt that there were two parts to the case. The one was the treatment of Michael, the treatment of Michael's family, the fact that he had drowned in the pit toilet, that his family was left to watch him in the pit toilet until emergency services had arrived. You know, when they tried to take pictures, the camera was taken away from the family, and they were treated really horrible throughout this process. Interestingly, the court judgment at the Supreme Court of Appeal level has been scathing of the treatment of the Department of Education, not only of the education authorities on the actual day in the circumstances I have described, but they have also said that this case was an indefensible case, and that the Department of Education should have never have defended it. They also took issue with the way the state advocate had denigrated the family during the cross-examination process. So for us, there is the systemic damage that has to be addressed, which is fixing the pit toilets, but the feelings and the vindication of the rights of the family is something that we wanted to see happen as well. And we want to make a statement that no human being, no matter their race, no matter their class, should not be treated like this. Yeah. We all have children that go to school. I have a child that is exactly the same age that Michael would have been, and we all empathize with that, and we don't want any child in this country to be treated that way.
Yeah, certainly. I mean, you and I both. I think that's the reality, is to think of losing your child in such a horrid way. It's not something that
it's horrible.
And the family, you will never get over this. But I imagine you've spoken to the family. How are they feeling at this point?
I have not spoken to the family personally, but people in my office have.
Yeah.
when our attorney first called Lydia Komape, who is one of the adult children in the family, she was overjoyed and was screaming when our attorney spoke to her. It's been a very long, hard road, and there's been so many heartbreaking moments and moments of hope and then losing hope, and it's been like that for a period of 5 years. The parents were not there at the time, but when I spoke to our attorneys last night, they said that both Mr. and Mrs. Komape were now understanding the judgment, were beginning to process the judgment, and were also very excited. And I think Mr. Komape has himself been doing a few interviews over the last 24 hours.
So let's understand the claim, because this is also a clause dealing with medical expenses. How exactly is that going to work for the family?
Well, the family have been receiving some kind of counseling for psychological trauma. And what had happened in the initial case was, while they had paid for the psychological trauma of the adults, the parents, and for the adult children, which is Lydia and Lucas, there hadn't been, and there are 3 minor children that were also receiving counseling. And one of the children hadn't paid medical expenses for one of those minor children. So now, in terms of the appeal, we had claimed damages for the minor children as well. So while the expenses for the adults had been covered, the medical expenses for the children haven't been covered. But going forward, that will be covered.
Okay. This is one story that we thankfully can say at least the family have got something. But there are many other families that at this point in time are still struggling for closure. There have been several other incidents that you've been looking into. I mean, I've got a list of them that are in front of me. How are they doing? I mean, we've got one of a 5-year-old Lumka Mketwa drowning after she fell into a pit latrine, and that was in the Eastern Cape. Sia Mtanda also dying in 2007 in the Eastern Cape, another one in Limpopo, Lister. As I say, the list goes on. How are the other cases looking?
So some of those cases have prescribed legally, and what had happened was, when we took on the Michael Komape case, parents came to us and said, you are dealing with Michael's case. We just want to tell you about our son's case or our daughter's case. And while we can't deal with those cases, like the 2007 case, for example, that has prescribed, the parents just wanted to tell us we can use the names and faces of their children to say this is not an isolated incident. Michael is not an isolated incident. Lumka Mketwa is not an isolated incident. So those are the prescribed cases. Then there are also the other cases where parents have come to us, and where we can't assist everybody, we have been facilitating very good legal representation for some of the other families. And, we now have a precedent since yesterday to assist these families in their cases. What Section27 also intends to do is that, in terms of the original High Court order, there was a part of that order that wasn't appealed by us, which was the structural order that said, find out how many pit toilets there are in Limpopo and fix them to government. Government then came back with a really bare bones ineffective order that said ineffective plan that said we will fix toilets by 2031. That is not good enough for us. So now that we've got the first part of the judgment, we intend to pursue a second part of this case, which is to ensure that government comes up with an effective and proper plan, and more importantly, implements that plan for the fixing of pit toilets in the province. As we know from the school regulations, for the regulations for school infrastructure, pit toilets have in fact been made unlawful, and all pit toilets should have been eradicated by 2016. So I think we've got a good case going forward to address kind of more systemic relief, and that will be our focus. At the same time, families everywhere should be emboldened to know that the this status quo is not good enough. And where they are unhappy with the status of toilets, where their family have suffered personal injury, they can take it up with lawyers. And where they're just dissatisfied, they can come to organizations like ours, like Equal Education, and we can challenge the status quo in many of these provinces around the disgusting state of sanitation, school sanitation, which is both unhealthy and unsafe.
And unconstitutional. I mean, let's just go there, because that at the bottom, at the end of the line is the problem. I mean, this is no child should go to school and not go to a toilet and die. I mean, it just doesn't make any sense whatsoever. It really doesn't. I just need to ask you, I mean, the school that this happened in, where Michael Komape actually died, lost his life, was Mahlodumela, and this was in Limpopo.
Yes.
Has Section 27, have you been back there? I mean, have pit toilets now been eradicated at that school at least?
Yes, interestingly, Section 27, following our involvement in the Limpopo textbook case, had been speaking to many of the schools in the province, and following the textbook saga, the next big issue for many of those schools was sanitation. And we had in fact been liaising with government, and government had agreed to fix the toilets in many of those schools. And one of those schools that had been earmarked for improvement and for renovation was this particular school, but nothing had happened at that particular school. Yes, since the death and since the publicity, there have been new toilets built at that particular school. But there are many, many more schools, and there are many, many more schools with 5-year-olds. And the problem with this is that 5-year-old learners are the most susceptible, because these pit toilets are not big enough to hold their little bodies. And that's when they fall in.
How are we doing? I know you spoke to it a bit earlier, that the goals that have been set by government. I mean, we know children are going back to school next month, and it was in August 2018 that President Ramaphosa said that pit toilets would be eradicated by 2020. That's next year. Basic Education Minister Angie Motshekga said that by 2022 all schools will have adequate sanitation. Have we been on top of this? I mean, are we on track to deliver this goal?
Civil society organizations like ourselves and like Equal Education have heard all the promises that have been made. Our concern is that when every time government data comes out on the number of pit toilets around the country, their numbers conflict not only with our numbers, but conflict with each other's numbers from the different data sets. And our issue is you can't fix a problem where you do not know the nature of the problem. You don't know the exact numbers of the toilets. So there's conflicting information around the number of toilets that need to be fixed, and there isn't enough being done fast enough in terms of ensuring that the correct companies are in place to fix the toilets and so forth. So while we think it's important to keep it on the agenda, we need more of a political will, and we need more happening within the department to ensure that pit toilets are eradicated. And in fact, other toilets that are also not in good condition that have to be fixed. But we are talking about pit toilets in this instance. But there are many other issues with school sanitation all over the country.
What else are we looking at? I mean, let's put it out there. Insufficient numbers of toilets. So you have overcrowding in toilets, and you have toilets being blocked and becoming unusable. You're still having instances where the toilets are so unusable, when girls, for example, are menstruating, they can't come to school. When you can't come to school, you're missing out on lessons, important learning and teaching time, which means you're missing out on your right to a basic education. That's one issue. You have issues of toilets that are not age appropriate. You have toilets that are unusable for learners with disabilities. There are many issues. You have toilets, that are just so badly broken down,
or where they have the huge issues of hygiene because they haven't been maintained and so forth. The list goes on.
Yeah, I mean these are real issues. The response from the Department of Education to all of this, and as we mentioned at the beginning of the interview, we had invited them into studio to come and join the conversation. They said that they're still studying this judgment, but your sort of interaction with them, their attitude towards this entire debacle and still the other issues that you're looking into, how has it been dealing with them?
You know, interestingly, I tend to be a bit of a know-it-all in my office. And one of the things that we had said from the beginning, and that I had said from the beginning, was that this case will never go to court. It's impossible that they would want to defend this case because it's indefensible. So in some senses, I feel vindicated by the judgment because it says that this case should have never gone to court. And that says a lot about the attitude of the department, that, you know, this is a case where they should have had a little bit more humanity. They should have thought about, you know, the way the family had suffered. They should have thought about the conditions of the toilet. I think there's a video doing the rounds on Twitter of the MEC for education at the time that said she is not the MEC for toilets. So that just gives you an example of their conduct. They are currently saying that they are looking at the judgment and will comment once they have looked at the judgment. I would like to say that I think the department would be really very silly to think of appealing this judgment because, as has been said over and over again, it's indefensible.
Yeah, I mean, I'm even reading the judgment. It's an article that's been written by Mark Hayward on the Daily Mavericks website, and he goes on to talk about how the judge, when handing down the Judge Leach, notes that in late in the day, the Department of Basic Education conceded that Michael's death had happened due to its negligence, and that a settlement had been offered and rejected by the Komapes.
Yes.
And it goes on to talk about how not once through this have the Department of Education actually shown any sympathy or empathy towards the family, and one would worry about that. You really would. I mean, that for me is hugely concerning.
Yes, and the settlement offer at the time was laughable, which is why we didn't accept it. And then we lost the case at the High Court level, and that was not okay for us because we knew that this was a case where the judge had misunderstood the larger claim for learners in Limpopo and the experience of the family itself. So we are very glad that the SCA was able to separate out these two issues.
All right, we're going to leave it there, and we thank so much for your time, and we thank so much to Section 27 for fighting for the family to find a little bit of closure, and as we say, precedent setting for all the other families that have lost their children in the same manner due to something as simple as going to a toilet and losing their lives. So that was joining us on in our Sea Point studio, Dr. Faranaaz Veriava, who is the head of educational rights at Section 27. That's that Supreme Court of Appeal in Bloemfontein yesterday awarding damages to the family of 5-year-old Michael Komape, who fell into a pit toilet and drowned in 2014. Crazy story. All right, that wraps that one up.